Yes, good evening to all the aspirants of the JCJ Junior Civil Judge 2022 conducted with Telangana State on 13th screening test. And the second part of the CRPC, today we are going to deal it. Yes, participant read what I posted on the screen so that I could know that you are with me and I am with you and both are traveling the same boat to reach to the destination. Anyone participants could read what I posted on the screen.
CRPC English with MCQ, Professor Dr. Mohammed Saheb Hussain, Professor. It doesn't show some.
And you have forgotten there, I put the Kolikonda Sharat Babu from the USA and the Motamari Sri Vidya from India. Is it visible or not visible?
Clearly not visible.
It is in black letters, it should be more visible there. Okay, that means you could see and you could read what it is there. Okay, speaking. Yes, now I turn to the Kolkanda Sharat Babu. You can continue from the 29th question.
Yes, sir. 29th question is, match the following chapters from part A, numbers with suitable explanation in part B. Part A, 1, chapter 15, 2, chapter 16, 3, chapter 17, 4, chapter 18. Now under part B are A, the charge, B, trial before a court of session, C, complaints to magistrates, D, commencement of proceedings before magistrates. So please scroll up. Now the options are A, 1C, 2D, 3B, 4A, option B, 1D, 2B, 3C, 4A, option C, 1A, 2C, 3B, 4D, option D, 1C, 2D, 3A, 4B.
Here part A, part B, I have shown it. And I am scrolling now. Shoot.
If you can shoot one answer, then we will let you know the real answer.
Anyone, are you there? Say pass on. There is no negative marks. Because the silent means...
Why don't you shoot rather than...
Say pass on.
Quiet.
Pass on, sir.
Even though it is wrong, you have to shoot it. Rather than the pass on. Yes.
Because of the screen problem.
Okay, because it is, I cannot make it a shot. If I could make it a shot again, we would say that,
yes,
sir,
yes.
you could not see it. Okay, feedback to the Sharat Babu.
Chapter 15 is complaints to magistrates. Chapter 16 is commencement of proceedings before magistrates. Chapter 17 is the charge. Chapter 18 is trial before a court of session.
So in the options, the D option is the right option. 1C, 2D, 3A, 4B. That is the right option.
Yes. Option D is the right answer. 1C, 2D, 3A, 4B.
Okay, now I can scroll down. It is also the same type of the question, right?
Now, 30th question is match the following chapters from part A numbers with suitable explanation in part B. And part A are 1, chapter 11, chapter 21. The second one is chapter 20. What is that, sir? Chapter
21, capital A.
Sorry. Yes, chapter 21, capital A. 3 is chapter 22, 4, chapter 23, and under part B, A is evidence in inquiries and trials, B is attendance of persons confined or detained in prisons, C is plea bargaining, D is summary trials.
And the options?
And the options are A, 1A, 2D, 3C, 4A, 4B. B is 1C, 2B, 3D, 4A. C is 1D, 2C, 3B, 4A. D is 1B, 2A, 3D, 4C.
Option C.
Option C.
Yes. Option C is the right answer. Feedback.
Option C is the right answer, and the feedback is chapter 21 summary trials. Chapter 21 A is capital A is plea bargaining. Chapter 22 is attendance of persons confined or detained in prisons. Chapter 23 is evidence in inquiries and trials. Now, 31st question is, the first capital A is inserted in the nearest number of section of CRPC is dash to which section? Option A 23, option B 24, option C 25, option D 26.
C.
Option C, 25.
Right.
Directorate of
Option
Prosecution.
C is the right answer. It is 25. Now, 32nd question. Which section deals about Directorate of Prosecution? Option A, section 25, option B, 25, capital A, option C, section 26, option D, section 26, capital A.
Option B.
Option
B, 25A.
Yes, right answer.
Option A, B is the right answer, section 25, capital A. 33rd question. In which chapter of CRPC there are a smaller or less number of sections? Capital A, chapter 1, option A, chapter 1, option B, chapter 4, option C, chapter 9, option D, chapter 13.
Option B.
Wrong.
Chapter 9. Option C. Option C, chapter 9.
Option C is the right answer.
Option C, chapter 9 contains less number of chapters.
Sections.
So option C is the right answer. Sections. 34th question is, public nuisance comes under which chapter of CRPC? Option A, chapter 9, option B, chapter 10, option C, chapter 11, option C, chapter 12.
Chapter 11.
Wrong.
Chapter 10.
Chapter 10. Option
Yes,
B.
10 is the right answer.
Yes, option is B. Option B is the right answer. Chapter 10 deals with public nuisance. 35th question. Offense committed on journey or voyage is dealt in the section of CRPC, dash of CRPC. Option A 181, option B 182, option C 183, option D 184.
Option C, 183.
3.
183.
You're right.
Option C is the right answer, 183. 36th question. Offense committed outside India is covered under dash of CRPC. Option A 186, option B 187, option C 188, option D 189.
Option C, 188.
Right.
Option C 188 is the right answer. Offense committed outside India, that is in foreign countries, comes under section 188. 37th question. Prosecution for defamation is spelled in section dash of Criminal Procedure Code. Option A 196, option B 197, option C 198, option D 199.
Option D. 199 D.
Right.
Option D 199 is the right answer, that deals with defamation. 38th question. If upon consideration of the record of the case and the documents submitted therewith, and after hearing the submission of the accused and the prosecution in this behalf, the judge considers that there is not sufficient ground for proceeding against the accused, he shall discharge the accused and record his reason for so doing, is known as dash, and under which section of dash of CRPC? A. Admission on 226, B. Confession on 227, C. Charge on 227, D. Discharge on 227.
D.
Option D,
Option
discharge.
D.
Wrong. No, it is right. It is right.
It is right, sir.
Yes,
In
right.
question also,
D is right.
in question also there is word discharge.
Yeah, yeah.
39th question. If after taking the evidence for the prosecution, examining the accused and hearing the prosecution and the defense on the point, the judge considers that there is no evidence that the accused committed the offense, the judge shall record an order of dash under which section dash of CRPC. A. Conviction and 231. B. Acquittal and 232 section. C. Admitted and 231 section. Option D is released and 232 section.
232 acquittal.
Option B.
Acquittal and 232.
Right answer. It's a B is the right answer. Acquittal and 232.
Acquittal and 232. Now, 40th question is, when the examination of the witnesses, if any, for the defense is complete, the prosecutor shall sum up his case and the accused or his pleader shall be entitled to reply, provided that where any point of law is raised by the accused or his pleader, the prosecution may, with the permission of the judge, make his submissions with regard to such point of law is said to be dash under section of dash CRPC. A. Arguments on 234. B. Acquittal on 232. C. Admitted on 231. D. Arrested on 232.
34 arguments.
Wrong. Second option.
Option D.
Wrong.
Option B again, acquittal and 230.
No. B is the right answer, what you said. Option B, acquittal and
Option B,
232.
acquittal and 230.
That is the right answer for that 40th question. Go to the 41.
Now, 41st question is, plea bargaining starts from which section dash and ends with which section dash of CRPC? A. 264 to 265 L.
Capital L.
Capital L. Option B. 265 small a to 265 capital L. C. 265 capital A to 265 capital T. Option D is 264 capital A to 265 capital I.
Option C is the correct answer. 265 capital A to
Option C.
265 capital L.
You are right.
That is L.
C is the correct answer.
265 A to 265 L. Okay.
Capital L.
42nd question. 42nd question. In the case of dash, it was held that a judgment is the act of judging. It was pointed out that judgment should clearly mention the reason for accepting an argument and rejecting the other. Option A, Santakas Police Station versus Imtiaz Amir Hamza Khan. Option B is Ismail Amir Shaikh versus the state of Maharashtra. Option C, Ibrahim Shaikh versus state of Bombay. D, none of them.
Option B.
Read.
Ismail
Read.
Amir Sheikh versus the state of Maharashtra.
You are right.
Option B is the right answer. Ismail Amir Shaikh versus the state of Maharashtra. So the judgment must state the reason.
Srividya, welcome. Do you want to host it?
Third question.
No, sir. Please
Okay.
carry on.
Continue.
What third question? Which of the following statements is not true under the provisions of Section 167 of the Code of Criminal Procedure 1973? Option A. The provision for release is mandatory in the sense that the accused shall have to be released on bail. I think it should be is mandatory. B. Magistrate has the power to remand accused the terrorists to army custody for investigation. Option C. The order under the section is a judicial order. Option D, on the expiry of 60 days from the date of the arrest of the accused, the further detention does not ipso facto become illegal.
Option C.
Option A.
Wrong.
Not true, madam.
Not true is a
Option D.
Read.
On the expiry of 60 days from the date of the arrest of the accused, the further detention does not ipso facto become illegal.
Wrong.
Option C is the correct answer.
Wrong.
option B inka.
Read. Option B, magistrate has the power to remand accused within parenthesis terrorist to army custody for investigation. No magistrate will go to army custody for investigation. Okay, let me start with the 44th question. So I'll take the part. Which of the following is not true of section 31 CRPC? A. It relates to the quantum of the punishment that the court has no jurisdiction to pass where the accused is convicted of 2 or more offences at one trial. B option. It is a rule of the procedural law. C option. Only A is true. D option. Both A and B.
Option B.
Repeat. Wrong.
Both A and B.
Wrong.
Actually, no answer, sir.
Then what is the right answer? What is the right answer?
Option C.
Option C only. A is the right answer. See, that is say, what I did know, it relates to the quantum of the punishment to the court has no jurisdiction. I removed the no, I put the jurisdiction. And actually it should be a has jurisdiction, not no jurisdiction. It has a jurisdiction. So that was not connected with that one. Is it clear?
Yes, sir.
45th question. Which of the following requirement need not be, I said need not be followed under section 200 of the Code of Criminal Procedure 1973? Option A, the complainant must be examined. Option B, examination of the complainant must be under oath. Option C, the accused must be given an opportunity to be heard. Option D, the examination of the complainant must be reduced to writing.
Option C.
Why C is that not? Can you tell me? Yes?
Option A.
Yeah, that is the right answer. The accused must be given an opportunity to be heard. So now the 46th question. Under the section 200, they need not be followed. No opportunity will be given under the 200. Otherwise, in other cases, an opportunity will be given to be heard. Audio alterum partem. 46th question. Imprisonment of illegal violates some of the most basic freedoms and right associated with a dash. A. Freedom. B option democracy. C option liberty. D option deeds.
Liberty.
Wrong.
Option A, freedom.
Wrong.
B, democracy.
Option B, democracy.
Option B is the right answer. Associated with the democracy, because it is the basic freedom of and rights. And 47th question. The various functionaries mentioned under the code are the, I think something is missed. Yeah, are the dash. Number A, private and public. B, prosecutor, assistant prosecutors. C, additional prosecutors, prison authorities and the defense counsel. D, all of the above.
All the above.
All of the above.
Hmm? Are you sure? The various
Option D.
functionaries mentioned under the code are the dash. All the above is not the right answer. Second option.
Prosecutors, assistant
Option
public prosecutors.
If option
D.
A is, let us presume that the right answer, then what is the reason?
Public.
Let us presume it is the right answer. Here there is no private, it should be a public. Private and there is something, that private and public is the right. And the code are that, the various functions mentioned in the code are the dash, private and public, and prosecutors. I think all of the above is the right answer.
If you just mention, sir, if you just mention private and public, that's enough, I think. Because all the, for example, experts, opinion of experts like that. And
Yeah. You are right. You are right. There will not be a private, it should be a public only.
I think private and public all are involved in this various
Option
functions.
A is right answer.
I think private people will not involved in the function is mentioned in the code. If the prosecutors involved, assistant prosecutors involved, additional prosecutors involved, prison authorities are involved, defense counsels are involved, but the private individual will not be involved. The public officials will be involved.
Okay, sir.
So A is the answer for that one. They are not involved. Of course, public are involved, but they're not the private. 48th question. At the lower level of the judiciary, the courts are called courts of judicial magistrate, which are of three types. Among four, one is false. Which one is? It is false. Number A, judicial magistrate. Of course, here J is missing. Judicial magistrates. B, judicial magistrate first class. C, judicial magistrate second class. And D, special magistrate court.
A.
Wrong.
D.
Why B is a wrong statement? Because it is clearly mentioned judicial magistrate second class they mentioned. They did not mention judicial magistrate first class.
Option D, special
Option D is the answer for the 48th question. 49th question is dash of the code of criminal. Yes.
40th question, which is the right answer? B?
It is a first class is not mentioned. B is the right answer. Yes. 49th question, dash of the code of criminal procedure defines public prosecutor. I quote, a person who is appointed under dash of CRPC and is also includes any person who is acting under the direction of the public prosecutor and court. Options A, section 24 and section 2 class U. B, section 2 class U section 24. C, section 24 and section 2 class V, and the none of the above.
E, 2U 24.
It is a 2 class U 24. That means B is the right answer. What is the right answer?
B.
B is the right answer for the 49th question. Okay, let me scroll down. Yeah, here again, section 2 class U of the Code of Criminal Procedure defines the public prosecutor and a person who is appointed under section 24 of the CRPC, and it also includes any person who is acting under the direction of the public prosecutor. So that is the entire thing. The 50th question. In India, it is necessary that the criminal justice system should function within the limits of the Indian Constitution, which means that it is necessary for the public prosecutor is in accordance with the principles of dash. Find the odd man out. It means one is not relevant among the four. What is that? Number 1, A, equity before law. B. Protection against the double jeopardy. C. Protection against the self-incrimination. D. Protection against the exposure law.
Option A.
D.
Wrong.
Option A, equity before law.
Option
Option A.
Option
Why
A,
equity before law is wrong? Tell me.
Because Article 20, there is 3 clauses are there, A, B, C.
Okay.
First
Now,
one
why
is
you say
double
the
jeopardy.
equity before law is wrong? What should be the exact wordings? Equality before law, not equity before law. It should be.
Yes, yes.
It should be.
Yes, sir. Yes, sir.
It should be.
Equality before law.
Yes, I want to see that you have to repeat it. That's my intention. Okay, 51 question. Anyone can unmute and read? Participants.
Where two or more courts have taken cognizance of the same offence and a question of arises as to which to them how to inquire into or try that offence. It's not visible, sir. Mobile.
Okay.
A option. The court where the proceedings are indicated earlier. Option B. The court where the proceedings are indicated later. Option C. High Court. Option D. Supreme Court.
Initiated.
Option C, High Court.
You are right.
Answer is
The
option
High
C,
Court
High Court.
is the answer for that question. Or the 52nd question, anyone can unmute and read? 52 question. This is appeared in the ILU conducted in the Pendekanti Law College, Chikadpalli.
under section
From there.
199 CRPC, a court can take cognizance of offence if the complaint is made within dash from the date on which the offence is alleged to have been committed. 3 years, 2 years, 1 year, 6 months. 6 months.
Option D, 6 months.
Yes. Next, anyone can unmute and read? Oh, it has gone. Okay, now, okay, read now.
Whenever a charge is altered or added after the commencement of the trial, the court may allow recall of witnesses under A. Section 216 CRPC, B. Section 217 CRPC, Section 311 CRPC, C. Option D, scroll, none of the above. Section
Option B is the correct answer.
217
Section 217 of CRPC.
217
It is
CRPC.
a B is the right answer. Section 217 CRP is the right answer for the question. 54th question I will read. 1. Section 374 CRPC deals with the appeals from convictions. 2. Section 375 CRPC provides that there is no appeal when accused pleads guilty. 3. Section 377 CRPC provides that there is no appeal in the petty cases. The 4th, Section 378, it deals with the appeals in case of acquittal. Yes, now 1, 2, 3, 4 is given over there. Now options are A, 1, 2, 3, 4 are correct. B, 1, 2, 3 are correct. C, 1, 4 are correct. D, 1, 2, 4 are correct.
This also come.
Option D,
Yes,
1, 2,
same
4 are
ILU.
correct.
Pendekanti Law College, Chikadpalli. From there, I tapped it CRPC. Yes, tell me.
Option D.
Option D, 1 is there,
Option
correct, 2
D.
is there, 4 are correct, but not the 3 petty offences will not come under it. And a 55th question, as per section 433 CRPC, who has the power to commute the sentence? A, state government. B, central government. C, appropriate government. D, none of the above.
Appropriate government. This also from A.
I told you the questions
Sir,
which I
after
made it from the
Ask
ILU.
other questions other than the
I told you in the beginning, the questions from ILU, Pendekanti Law College, Chikadpalli, Hyderabad, Telangana State, South India, India. Is it clear?
Okay, sir.
I told you that I have taken from there. Section 313 proceeding of the CRPC can be invoked in dash every trial, B every inquiry, and C either A or B, and D neither A nor B.
Either A or B.
It is the answer is either A or B, because I believe that it is Hindu. Are you Hindu? You did it. Because it is you who have sent me. 57th question. Every warrant of arrest issued by a court shall A. Be in writing. Option B. Be in writing signed by the presiding officer. Option C. Be in writing signed by any officer of the court. D. Be in writing signed by the presiding officer and bear the seal of the court.
Option D.
Option D is the right answer. It should be in writing, signed by the presiding officer, and bear the seal of the court. And a 58th question. Under section 108 CRPC, who has the power? A. Executive magistrate. B. Judicial magistrate. C. Court of Sessions. D. All of the above.
Executive magistrate.
Yes, this is also from the ILU, but this is not from the ILU. The proclamation 59.
This is also from ILU.
Is it? It is publicly read in the some constitution. Oh, yes, yes. This is also from ILU. The proclamation shall be published as follows, which is a false. A. It shall be publicly read in some conspicuous place of the town or village in which such persons ordinarily resides. B. It shall be fixed to some conspicuous part of the house or homestead in which such person ordinarily resides, or to some conspicuous place of such town or village. And C option, a copy there shall be fixed to some conspicuous part of the courthouse. And the D, the court may also, if it thinks fit, direct a copy of the proclamation to be published in a newspaper circulating in the place in which such a person ordinarily resides.
Option A.
Wrong. Yes, tell me. I modified. I modified it. That's why it's a little difficulty for you to make it which statement is false. It is very difficult to make it out unless until you are thorough enough. So first one is not false, is the correct. It shall be affixed.
Option B.
Pardon?
Option B. The house or homestead. Homestead there is.
No, it is the correct. It is there. House or homestead in which such person ordinarily resides, to some conspicuous place of such town or village. Yes, it is there. It is also correct. A copy there shall be affixed to some conspicuous part of the house. Oh, okay. I will give the D is the wrong. Can you tell me why D is the wrong, anyone? D is the wrong. Can you tell me, anyone?
Court would direct a copy another. So
the court may also, if it
Court
thinks,
may also.
direct a copy of the proclamation to be published in a newspaper circulating in the place in which such a person is ordinarily resides.
A newspaper is made public to all, not only where the place he resides.
I want to say what word I omitted so that it will not be a false. I omitted certain word. Just use the common sense, you could know it. Newspaper, I omitted certain word. Daily.
yes, yes.
I removed the daily newspaper and I highlighted in the red. Did you see it? Say yes.
Yes, sir.
See, this way also,
Super.
I am giving the different techniques so that even I tested myself. I failed in 2, but I succeeded in the remaining in CRPC. I tested myself.
This is not ILU question paper, sir. This is not ILU question.
But
I go for only from ILU. This is your question, your special question from you.
anyway, that is, let us see that, because this is I prepared. It's not I borrowed the idea. I modified it, then I put it there. Okay, now to the 60th question.
Okay.
Math, shall I proceed? Shall I proceed?
Yes, sir.
Yes, sir.
60th question. Match the following section from part A and its explanation in part B. Part A, section 105, capital C. 2, section 105, capital D. 3, section 105, capital E. 4, section 105, capital F. Part B, management of the property seized or forfeited under this chapter. B, seizure or attachment of property. C, identifying the unlawfully acquired property. D, assistance in relation to orders of attachment or forfeiture of the property. And options A, 1B, 2C, 3A, 4D. B, 1A, 2D, 3B, 4C. C, 1D, 2C, 3A, 4B. D, 1D, 2C, 3B, 4A.
D, C, A, B.
Which one is the correct answer among the A, B, C, D? 4 options.
C.
Wrong.
Option D.
It's right. See the feedback, you can see it. Section 105C, assistance in relation to the orders of the attachment or the forfeiture of the property. And when you come to the section 105D, identifying the unlawful acquired property. And section 105E, capital E, seizure or attachment of the property. And the fourth section 105, capital F, management of the property seized or forfeited under this chapter. And I told you that Professor Hussain students will not say 0, 105 capital F. And they don't say 105 and capital F. They say 105 and capital F. I already told you that what is the not spelling?
NAUGHT.
Already I told you. Repeat. Participants.
NAUGHT.
Either you can write NAUGHT or you can write NOUGHT. Both are right. Not KNOT, not. Is it clear? Say yes. Okay, 61 question. Which one false statement or wrong or false section in CRPC? 1973. Section 53A. Examination of the person accused of rape by medical practitioner. Option B, section 54, capital A, identification of the person arrested. Option C, section 55, capital A, health and safety of the arrested person. Option D, section 56, capital A, arrest to be made strictly according to the code.
Option D.
Option D, section 50.
There is no 56, capital A.
To be made strictly according to the.
There is no capital 56, capital A. And hence,
Yes, sir.
right
It
answer is
should be 60A.
yes. See here,
Option D.
there is no 60A. I will show you it. Can you able to see it? There is no 56A. This is the 60A is there. Is it clear? Is it visible?
Yes, sir. Yes.
Can you read 55A?
Yes, sir.
55A.
Health and safety of arrested person.
And there is no 56A, but I wrote 56A. I changed 60A. That is the arrest to be made strictly according to the code.
Yes.
Is it clear?
Yes, sir. Clear.
Yes, and these are the things which I prepared it today. And still, would you have at least 5 to 7 minutes in your hand? But the supplementary questions, it is the easy questions. I did not mention it, but they have mentioned in the today's ILU when the Hindu Marriage Act is enforced. Is it not?
18th May 1955.
Yes, and I have both the ILU model examination and its key also with me, because I'm very much thankful to the Hindu, and she has sent me to post it. I already posted it, and this is the Okay, let me test you till it ends. The Hindu Marriage Act 1955 came into force with effect from A, B, C, D. The A, 18th April 1955, B, 18 May 1955, C, 18 June 1955, D, 18 July 1955. Sharath, you can continue it.
Option B.
Option B, 18th May
Option B.
1955.
18th May.
Okay, Sharath Babu, continue it.
Second question is, when two persons are descendants from a common ancestor by the same wife, they are related to each other by A. Option A, full blood. Option B, half blood. Option C, uterine blood. Option D, red blood.
Option A, blood.
Option A, full blood.
Is it the thing when two persons are descended from a common ancestor by the same wife?
Yes,
Sir,
that is
uterine
full blood.
blood.
Option A is correct answer. Full blood.
Uterine blood.
Uterine blood.
Okay,
Yes, uterine blood.
I have the answer also.
Full blood, I think.
Yeah, let us see. Because it's a, what question it is? Second question, no? It is the second question, is it not?
Second question, yes.
Yes, 2A, full blood is right answer. Because generally we will commit a mistake stating that it's a uterine blood, because when you say wife means mother. Okay, next.
When, okay, sir. Please. Third question, while awarding maintenance, pendant, life, and expenses of proceedings under Section 24 of Hindu Marriage Act, court should consider option A, income of petitioner, option B, income of respondent, option C, either A or B, option D, both A and B.
Option D, both A and B.
Both A and B.
Because they also see if the wife is the earning member or a spouse is the earning member, then you cannot get that much. If she is a housewife, okay, then they will definitely they see the respondent's income. Am I right?
Yes.
Okay, next.
Yes, sir.
Even if the wife is an earning member, then
Less.
she is also compelled. Okay.
No, she will
Fourth
be entitled,
question,
but less.
Fourth question, an interim order passed under Section 26 of Hindu Marriage Act can be challenged before an appellate court within option A 30 days, option B 60 days, option C 90 days, option D none of the above.
Option D.
Then what would be the right answer? What would be the right answer? What is the question? This is which question?
Yes, sir. Yeah.
Fourth question.
Is the fourth question. Oh, this variance gap. Is it scrolled completely? I remove this one.
Appeal can be done to 90
That is
days
not
or-
appeal, sir. They are confused. That is not appeal. Section
Okay,
20.
because I don't know why, because I already kept it here, that key. Let me open it once again. Yes, this key already kept it here. Fourth question. D, correct. What is the none of the above is correct. Okay, now let us go to the next question. Fifth question.
Yes, sir. Of the following, who is a class 1 heir? A, daughter, B, sister, C, brother, D, all the above.
Daughter.
Option A, daughter.
Option A, daughter.
Yes, class 1 hairs comes. Okay, next.
Option A is the right answer. Next, 6 promises which form the consideration or part of the consideration for each other are called A, contracts, B, agreements, C, bilateral promises, C, reciprocal promises.
Option D, reciprocal promises.
Yeah, I think it is right. Can we check it?
No.
Not necessarily. Okay. Next.
Option 7, question number 7. Which provision of Hindu Succession Act deals with a presumption in case of simultaneous death? A, Section 18, B, Section 19, C, Section 20, D, Section 21.
D, section 21.
D, section 21.
Yes. Next.
Option D is the right answer. Next. Eighth question. A person who commits the murder or abets the commission of murder, option A, may be disqualified from inheriting any property. B, may be disqualified from inheriting any property of the person murdered. C, shall be disqualified from inheriting any property. D, shall be disqualified from inheriting any property of the person murdered.
Option D.
Yes.
I think option D is the right answer.
Yeah, you are right.
We have already asked this question earlier.
Yeah. At least it is a revision to the other people, no? Next.
Ninth question. When an order is passed by the controller in execution under Section 15 of Rent Control Act, such order can be challenged by A, appeal, B, revision, C, either A or B, D, neither A nor B.
Option B, revision.
Revision.
Okay. I think it is right.
Option B is the right answer. Revision. 10th question. Where an eviction order is passed against a tenant, such order binds A, tenant only, B, subtenant also, C, subtenant who is made as party to the suit, D, none of the above.
Subtenant also. Option B.
Yeah, but he is party to the suit. 11th.
11th question. When, so for 10th question, what is the answer?
It is a C, subtenant who is made also a party to the suit.
No, sir. Option B, subtenant
Option
also.
B. Let me check it. Okay. If any doubt is there, no, better we check it. I don't know where I kept it. It is here. Okay, now I got it.
Unless
What is the number? 10th. Is it 10th?
Yes, sir.
Is it the 10th?
Yes, sir.
Oh, B. 10th B is the right answer. Yeah, subtenant also. Okay, next. 11th.
When two or more courts have taken cognizance of the same offense and a question arises as to which of them ought to try that offense, the question shall be decided by A, the court where the proceedings are initiated earlier, B, the court where the proceedings are initiated later, C, High Court, D, Supreme Court.
I think we did it this one. CRPC, we
Option
did it.
C, High Court. Yes, sir.
We did it. No, I scroll down. We did it. All the CRPC, we did it. I scroll down.
Yes, High Court, sir.
Yes, sir. Because we did it. We already did it. Hence, I am scrolling down. Yeah, from here we read 21.
Substituted performance of a contract is provided under A, Section 20 of SR Act, B, Section 20, capital A of SR Act, option C, Section 20, capital B of SR Act, option D, Section 20C of SR Act.
Option A.
A of A, 20.
Shall I check? 21.
Yes, sir.
21 is the A. 21 is the A. Section 20 of what is SR Act?
Specific Relief Act.
Good. 22.
A suit under Section 6 of SR Act cannot be filed against a woman, B, the government, C, both A and B, D, either A or B.
Option B, the government.
Option B, the government.
Yes,
Okay.
option B is the right answer.
Okay.
Twenty-third question. A person who ratifies a contract either expressly or impliedly A can file a suit of rescission of contract. B cannot file for rescission of contract. C, it depends on the facts of the case. D, it is at the discretion of the court.
Option B, cannot file a suit for rescission of your contract.
Yes, you are right. because he himself made
Next.
such an express and implied contract. Next.
24th question. Whether an instrument can be cancelled in part. A, yes. B, yes with the leave of the court. C, yes with the consent of the parties. D, no.
Option A, yes.
Yes, an instrument, because the negotiable instrument, you do have every right to cancel it. Next.
25th question. A will may be presented for registration within A, 3 months from the date of execution. B, 4 months from the date of execution. C, 1 year from the date of execution. D, at any time.
Option D, at any time.
4 months.
No. Option D, at any time. That is a
Let me
will.
see, 25th.
Option
Check
D
it.
may be the right answer, sir.
Yeah, 25th is D. If it is the 25th, it's a D answer.
It may be registered at any time.
D answer, 25th. Yes.
Yes.
Many
Yes,
times.
sir.
26th question. If a document remains unclaimed in any registration office for a period exceeding dash, may be destroyed. A, 1 year. B, 2 years. C, 3 years. D, none of the above.
Option
Within
B,
2 years. B.
2 years.
Option D, I think, sir.
Let us check. Why doubt? What is the question number?
Either it must be
26.
C or D.
26.
26B. It is the 26, it is a B is the right answer.
2 years. So within 2 years, if
Within 2 years only that you are going to make it out.
if it is not claimed, then it can be destroyed.
Yeah.
27th question. The list of the documents prohibited from registration is provided under A, Section 17(2) of Registration Act, B, Section 18 of Registration Act, C, Section 22, capital A of Registration Act, D, Section 23, capital A of Registration Act.
Option D, 23A of Registration Act.
Okay. Next.
28th question. Where the registrar refuses to order the document to be registered under Section 72 or Section 76 of the Registration Act, the aggrieved person can A, refer an appeal, B, file a suit for mandatory injunction, C, either A or B, D, neither A nor B.
Option B, file a suit for mandatory injunction.
Let me check it. Because the option will be given the true. What is the number?
28.
28. B is the answer. Where is that? 28. No, not this one. Yeah. The B is the answer. File a suit, mandatory injunction. Right. Next.
29th question. A document which is not duly stamped and not registered may be A, admitted in evidence to prove a contract in a suit for specific performance. B, admitted to prove a collateral transaction and not required to be affected by registered instrument. C, either A or B. D, neither A nor B.
Option B.
29th. Let's check it. 29th right answer is D.
Yeah.
29th right answer is D. Either A? Yes, out. Time is up. I think still it is there. Yeah, it is there. Okay, next. Next.
Next 30th question, sir. Every document by which any right or liability is or purports to be created, transferred, limited, extended, extinguished, or recorded is known as A, settlement, B, conveyance, C, instrument, D, bond.
Option C, instrument.
Okay. Next.
31. Whether a police officer can be impound an instrument not duly stamped. A, no. B, yes. C, yes with the leave of the court. T, yes, with the previous permission of the government.
Option A, no.
Okay. 32nd. Okay, let me read the 32nd. Where an instrument not only stamped is admitted in evidence during the trial, its admissions can be questioned. A. Option at any stage of the suit. B. Option in appeal. C. Option in revision. D. Option either B or C.
Option C in revision.
In revision. I need not to check it.
Yes, sir.
Okay. 33. A proposal may be revoked. Okay. A proposal may be revoked at any time before the communication of its acceptance is complete.
सारे जहां से अच्छा हिंदुस्तान हमारा। जय हिंद।
Jai Hind.